My mom sent me a text the morning of the custody hearing. Not a good luck message. Not an I love you. Just 4 words. Don't embarrass our family. I read it twice, standing in the parking garage of the Maricopa County Courthouse, my reflection staring back at me in the dark window of a stranger's car. I was wearing the same blazer I'd worn to every performance review for the past 6 years. My hair was flat-ironed, my folder was color-coded, and my hands, if I'm being honest, were shaking just enough to notice. I put the phone in my bag and walked toward the entrance. She was already inside. My mother, Carol, sitting with her arms crossed next to my ex-husband's attorney, a woman named Diana Holt, who had a reputation in Phoenix family court circles for being surgically precise and professionally merciless. My mother had hired her, not for herself, for Marcus. She had paid a stranger to take my daughter away from me, and she had done it with the same calm efficiency she used to plan holiday dinners. I had no attorney. I'd had one, briefly. His name was Greg, and he'd been decent, patient, methodical. But after Marcus's team began filing motion after motion, extension after extension, the retainer ran dry in 4 months. I called 3 other firms. The consultations ended the same way every time. A sympathetic nod. A folder slid across the desk, a number with too many zeros. I was a pediatric occupational therapist working 4 days a week, so I could be home with my daughter Lily on Fridays. I drove a 2016 Civic with a cracked dashboard. I was not the client those firms were looking for. So when I walked into Judge Patricia Okafor's courtroom that Tuesday morning in March and took my seat at the respondent's table alone, every single person in that room had already decided how this was going to end, including my mother. She leaned over the divider and said, loud enough for the clerk to glance up, "You should have taken the settlement, Lauren. Now you're just going to humiliate yourself." The man sitting beside her, my ex-husband Marcus, said nothing. He didn't need to. His attorney said everything with a single glance in my direction, the kind of look that means I've already won this and we both know it. The bailiff called the room to order. And then, I opened my binder. What happened next took 14 minutes to reach the moment where even the court reporter looked up from her screen. 14 minutes that unraveled 2 years of my mother's certainty, my ex-husband's strategy, and every assumption anyone in that room had made about what I was and wasn't capable of. But to understand that moment, you have to understand how I got there, because none of it was an accident. And none of it started in that courtroom. My mother has a very specific theory about the kind of woman who deserves good things. She is organized. She is visually presentable. She does not cry in front of people who matter. She does not struggle in ways that other people can see. She marries the right person, stays married, and when things get difficult, she finds a way to smooth the difficulty over, rather than pulling it into the light, where everyone has to look at it. By her metric, I had been failing since I was about 23. I got my degree in occupational therapy because I genuinely loved the work. I loved sitting on the floor with 4-year-olds who couldn't hold pencils yet and watching the moment something clicked. I loved the science of it, the specificity of it, the way every child was a different kind of puzzle and every session was a different kind of solution. My mother called it a fine career for someone who didn't have other options. Marcus, on the other hand, she adored from the beginning. He was tall and had good shoes and worked in commercial real estate. He had the kind of handshake my mother described as substantial. She used that word a lot when talking about him. Substantial. As if the rest of us were somehow made of thinner material. We got married when I was 28. Lily came a year later, 7 pounds 4 ounces, with her father's cheekbones and my stubbornness. And I knew from the moment I held her that she was the truest thing I'd ever done. The marriage was already fraying at the edges by then, held together mostly by logistics and the quiet mutual understanding that neither of us wanted to be the one to say it first. Marcus said it first. 2 days after Lily's 2nd birthday, over takeout containers on a kitchen counter, the way you might mention a leaky faucet. "I think we should separate." Calm, measured, already decided. He'd been speaking to someone, he added. A therapist. He felt the relationship had run its natural course. He did not mention that the someone was also a 26-year-old woman named Priya who worked in his office. I found that out from his sister 6 weeks later. I'm not telling you any of this for sympathy. I'm telling you because it matters to what came next, which is that Marcus handled the separation the same way he handled everything else, with precision and strategy and a complete absence of visible emotion. Within a month, he had a family law attorney. Within 3 months, he had a parenting plan drafted that would have given him primary physical custody of Lily, with me receiving every other weekend and 1 evening per week. Every other weekend. Lily was 3 years old and I had been her primary parent every single day of her life. And someone had typed those words into a legal document and my mother had looked at it and said, "Well, Lauren, maybe you should consider whether primary custody is really sustainable given your situation." My situation. As if Lily were a houseplant, I was struggling to keep alive rather than a child I had arranged my entire professional and personal life around for 3 years. I hired Greg. I fought back. I filed a counter-proposal. 18 months of hearings and continuances and discovery requests and depositions followed, eating through every dollar I had set aside and a few thousand I had to borrow from my friend Dana. And through all of it, my mother remained firmly, visibly, in Marcus's corner. She showed up to his support hearings. She had coffee with Diana Holt. She told anyone who would listen that she just wanted what was best for Lily, and what was best for Lily was stability. And Lauren, God love her, had never quite managed to be stable. The word she used more than once was erratic. I am not erratic. I am a woman who went through a difficult divorce while working full-time and raising a toddler. And the difference between those two things is something my mother has never chosen to understand. When Greg told me he couldn't continue without another retainer I couldn't afford, I sat in my car outside his office for 45 minutes, not crying, just thinking. Thinking about Lily's voice when she woke up from bad dreams. Thinking about the way she asked for me specifically, by name, with a particular urgency that I knew in my bones was the sound of needing the person who had always been there. I was not going to let that be taken from her because I couldn't afford to pay someone to speak for me. So I decided to speak for myself. I want to be very honest about what the next 8 months looked like, because it was not a movie montage. It was not inspiring background music and time-lapse shots of me highlighting legal documents. It was exhausting and confusing, and there were nights I sat at my kitchen table after Lily was asleep and genuinely could not tell if what I was reading was useful or completely irrelevant to my situation. Occupational therapy trains your brain in a very specific way. You learn to break complex tasks into component parts. You learn to identify what the actual barrier is, not what it looks like on the surface, and address that barrier directly. You learn that most of the time when something seems overwhelming, it's because you haven't yet figured out which piece to pick up first. I applied that exact framework to family law. The first thing I did was go to the Maricopa County Law Library and ask the librarian, a patient man named Gerald who clearly had seen terrified self-represented litigants before, to point me toward the Arizona Family Court self-help resources. He handed me a binder of his own, already assembled, and said, "Most people who come in here don't read the whole thing. You should read the whole thing." I read the whole thing twice. Then I started reading the actual statutes. Arizona Revised Statutes. Title 25. Domestic Relations. I printed everything relevant, used 3 different colors of highlighter yellow for statutes, orange for case law, pink for anything that directly contradicted a claim Marcus's team had made in their filings, and read each section slowly, the way I read therapy assessments, looking for patterns, looking for what was actually being said underneath the language. The first thing I found was that Arizona family courts apply a best interests standard with 14 enumerated factors. Marcus's attorney had structured their entire custody argument around 2 of those factors: financial stability and consistency of routine. She had barely addressed the other 12. I wrote down all 12. Then I spent the next 6 months building documented evidence for every single one of them. I kept a communication log. Every interaction with Marcus, every exchange about Lily's schedule, every unanswered message, every last-minute cancellation, time-stamped and printed. I requested Lily's pediatric records going back 3 years, and organized them into a timeline showing who had attended every appointment, who had filled every prescription, who had called the after-hours nurse line at 11:30 on a Tuesday when Lily had a fever of 103. It was me. Every single time, it was me. I found a nonprofit legal clinic that offered free 30-minute consultations for self-represented parents in family court. I went 4 times, prepared with specific questions each visit, and took notes the way I used to take notes in graduate school. Structured, detailed, actionable. The attorney I saw on my 3rd visit, a woman named Rosa who was clearly working twice as hard as she had time for, looked at my documentation and said, "You understand that most represented parties don't come in with this level of preparation." I told her I used to work with children who couldn't advocate for themselves. I learned early that if you wanted to help someone who couldn't speak for themselves, you had to become the most prepared person in the room. She looked at me for a moment and then said, "Keep doing exactly what you're doing." I kept doing exactly what I was doing. The hardest part wasn't the research. The hardest part was doing it in the margins of a life that didn't pause while I prepared. Lily still needed dinner and bath time and someone to read the same 3 picture books in the same order every single night. My caseload at the clinic didn't shrink. The car needed new rear brakes in November, and that was $400 I didn't have comfortably. Dana brought me soup twice when I was sick, and I cried both times because I didn't have the energy to pretend I was fine. But I kept going, because there was one thing I knew with absolute certainty. The kind of certainty you don't arrive at by thinking but by feeling. Somewhere below rational thought in the part of you that just knows, Lily needed me to be her mother the way I had always been her mother, present and consistent and close, and there was no version of any outcome where I was willing to let that be reduced to every other weekend without using every resource I had. So I prepared. And then I prepared more. And when the hearing date finally appeared on my calendar, I had 4 organized folders, a timeline document that ran 11 pages, and a specific response prepared for every argument Diana Holt had raised in her pre-hearing brief. The night before the hearing, my mother called. "Lauren," she said, "the way she's said my name my entire life, with a slight exhale before it, as if saying it requires effort. I want you to know that whatever happens tomorrow, this wasn't personal." I asked her what she meant. "Marcus just needs a fair outcome," she said. "And you putting yourself through all of this without an attorney, it's going to reflect on you. Judge Okafor doesn't like chaos." I told her I wasn't planning to bring chaos. I was planning to bring documentation. She sighed. "Lauren, honey, you're not a lawyer." "No," I said, "but I'm Lily's mother, and tomorrow I'm going to make sure that's on the record." She was quiet for a moment. "Then don't embarrass our family." I hung up. I made myself a cup of tea. I read through my folders one more time. Then I went to bed, and I slept better than I had in months, because there was nothing left to prepare. I had done everything I could do. Whatever happened now, I had left nothing on the table. The morning of the hearing moved the way mornings do when something large is waiting at the end of them, slightly unreal, slightly too vivid. The coffee tasted sharper than usual. The drive downtown was quieter than usual. The courthouse smelled like carpet cleaner and recycled air and the specific kind of fluorescent lighting that makes everyone look slightly ill. I checked in at the clerk's window. I arranged my folders on the respondent's table. I wrote the date in the top right corner of my legal pad, which was a habit from graduate school that I'd never stopped. Marcus arrived with Diana Holt at 8:52. He was wearing a navy suit I recognized from a firm event 3 years ago. He didn't look at me. Diana glanced over with a professional assessment that lasted about 1 second, registered pro se respondent, and dismissed me with the efficiency of someone who has done this many times. My mother came in behind them and took a seat in the gallery directly behind Marcus's table. She was wearing her pearls. She wore pearls to anything she considered important. She looked at me across the room. Not warmly. Then she leaned forward and spoke clearly, the words I already told you. "You should have taken the settlement, Lauren. Now you're just going to humiliate yourself." I looked at her for one long moment. Then I turned back to my folders. Judge Okafor entered at 9:02. She was a compact woman in her late 50s, with reading glasses on a chain and the expression of someone who has heard every possible story and is no longer surprised by any of them. but who is still, underneath that, genuinely paying attention. I had read 3 of her published opinions during my research. She was methodical. She was fair. She did not like theatrics, and she had sanctioned 2 attorneys in the past year for what she described in her written orders as performative presentation over substantive argument. I had liked her before I walked into her courtroom. Sitting there, watching her settle her glasses on her nose and open the case file, I felt something I hadn't expected to feel: calm. Not the performative kind. Real calm. The kind that comes from preparation. From knowing that you have done the work. Parties will identify themselves for the record, Judge Okafor said. Diana Holt stood smoothly. Diana Holt, counsel for petitioner Marcus Webb. Then it was my turn. I stood. Lauren Carr, appearing pro se, respondent. From the gallery, someone exhaled audibly. It might have been my mother. Marcus studied the surface of the table in front of him. Diana made a small note on her legal pad. Judge Okafor looked at me over her glasses. Ms. Carr, you understand your rights regarding self-representation and you're choosing to proceed without counsel today? Yes, Your Honor. She nodded once and returned to the file. Petitioner may proceed. Diana stood and began with the confidence of someone who has walked into 100 rooms like this one. Her voice was even persuasive, architecturally constructed. She presented the custody modification request as a simple matter of a child's best interests. A father with demonstrated financial stability seeking to provide consistency. A mother whose circumstances had become, she said the word carefully, unpredictable. She cited the financial gap between Marcus's household income and mine. She cited 2 occasions in the past year when Lily's school pickup had been handled by my friend Dana rather than by me, both days when I'd had emergency client sessions that ran long. She cited Marcus's new home in Scottsdale, a 4-bedroom house in a good school district with a yard and a playroom. She didn't mention that Marcus had moved Priya into that house 3 months earlier. She didn't mention that Lily came home from her father's weekends and asked, twice, why the lady at Daddy's house didn't like her. She didn't mention that Marcus had missed 14 scheduled video calls with Lily in the past 18 months, that I had the timestamps and screenshots of every single one. She set down her notes with a small, decisive gesture and said, "The petitioner respectfully requests that the court find primary physical custody serves Lily's best interests." She sat down. Judge Okafor turned to me. "Ms. Carr, your response?" I stood. I opened the first folder to the tab I'd marked in blue, and I began. "Your Honor," I said, my voice even, the way it is when I'm running a session with a child who startles easily, calm and grounded and deliberate. I'd like to address each of the 14 best interest factors enumerated under Arizona Revised Statutes, Section 25 to 403. Because the petitioner's presentation has addressed 2 of them. The room went quiet in a way I hadn't anticipated. Not silent exactly, but stilled. Diana looked up from her notes. Marcus's head moved slightly, a fractional turn toward me. Judge Okafor leaned forward almost imperceptibly, and I knew not from arrogance but from reading 3 of her published opinions that she was interested. "Proceed," she said. I proceeded. There's a specific quality to a room when the person everyone assumed would lose turns out to know exactly what they're doing. It's not quite surprise. It's more like a recalibration. A moment where every person present is silently revising their assumptions and not entirely sure what to do with the revision. I felt the room do that. I went through the factors methodically. Not quickly, not performing, not trying to sound like a lawyer. I was presenting information the same way I present evaluation results to parents, clearly, specifically, grounded in documentation, explaining what each piece meant and why it was relevant. The child's relationship with each parent. I had attendance records from Lily's preschool going back 18 months. My name was on 94% of the pickup and drop-off logs. Marcus's name was on 11%, and 8 of those were in the 3 months immediately following the initial filing, a pattern I noted for the court's consideration. Each parent's past, present, and potential future compliance with parenting time. I presented the call log, 14 missed video calls, each one documented with a screenshot of the scheduled time, the attempted connection, and the non-response. I had Lily's text messages to me on 3 of those evenings. She was 5 now. She could type simple messages on the tablet she used for bedtime stories, asking why Daddy didn't answer. I did not read those messages aloud. I submitted them as Exhibit F and let the judge read them herself. Diana interjected twice. The judge allowed me to continue both times. The mental and physical health of all individuals involved. I presented a letter from Lily's pediatrician, Dr. Anitha Rajan, summarizing Lily's health history and noting that her primary caregiver contact had been consistent and responsive throughout her care. I had not asked Dr. Rajan to advocate for me. I had asked her to state facts. Facts were what she provided. Which parent was more likely to allow frequent and meaningful contact with the other parent? I flagged, carefully and without editorializing, that Marcus had requested in his initial filing that my parenting time be limited to supervised visits, pending a psychological evaluation that his team had ultimately not pursued. I let the court draw its own conclusions about what that request had been intended to accomplish. Diana tried to object. Your Honor, the petitioner withdrew that request voluntarily. It was in the filing, I said quietly. The judge looked at Diana. It was in the filing, counselor. Diana sat back. I had not raised my voice once. I had not cried, though there were 2 moments where I had to take a slow breath that probably looked like a pause for emphasis, but was actually me keeping myself together. I had not looked at my mother, not once, since I stood up. This was not about her. It had never been about her, not really, even when she made it feel that way. When I reached the final folder, I paused for just a moment. This was the piece I had debated, including, not because it was weak, it was the strongest thing I had, but because it was personal in a way the rest of the documentation wasn't. And I had spent 3 weeks deciding whether to use it. I decided to use it. Your Honor, I said, I'd like to submit one final exhibit. It's a collection of calendar entries, handwritten, maintained by Lily herself with my assistance over the past 4 months. She marks which parent she was with each day, using stickers. She initiated this herself after a visit to my clinic, where she observed an older child using a similar visual schedule. I walked to the bench and placed the exhibit with the clerk. She uses yellow stars for days with me and blue rockets for days with her father. In 4 months, she has placed 212 stickers. I'll ask the court to note the distribution. The room was absolutely still. Judge Okafor looked at the calendar for a long moment. From the gallery behind Marcus's table, I heard my mother make a sound I had never heard from her before. Not a word, just a sound, small and involuntary, the kind that escapes when something reaches you before your defenses can stop it. I returned to my table. I closed my folder. I said, "That concludes my response, Your Honor." Judge Okafor called a recess before issuing her preliminary findings. 15 minutes. The room exhaled. Marcus stood abruptly and walked toward the exit without looking at me. Diana Holt gathered her papers with the methodical efficiency of someone buying time to think. 2 of the clerks were conferring quietly near the bench, though I couldn't hear what they were saying. I stayed at my table and drank the water that had been sitting in front of me untouched for the past hour. My mother appeared at the divider. She looked different than she had when she walked in. Not smaller, exactly, just less certain. The pearls were the same. The posture was the same. But something around her eyes had changed. The specific quality of someone who has just witnessed something they weren't prepared for. "Where did you learn all of that?" she asked. I looked at her. The law library. The self-help clinic. 8 months of reading after Lily was in bed. She said nothing for a moment. "You never told me you were doing this." "You were paying Marcus's attorney," I said. Not accusatorially. Just as a fact. She flinched, and I realized that was the first time I had said it directly. We had both been existing in the polite fiction that she was just supporting her grandson's father, that it wasn't a choice made against me. Saying it plainly seemed to clarify something for her that the implication had allowed her to avoid. "Lauren," she started. Diana Holt appeared beside her. "Mrs. Carr," she said, with the careful neutrality of an attorney who now understood she had made several assumptions she needed to revisit. She looked at me. "Ms. Carr, your presentation was thorough. I want you to know that." I thanked her. She lowered her voice slightly. "For what it's worth, if you'd come to my firm 18 months ago, I would have taken your case. The documentation alone. I couldn't afford your firm, I said. She nodded once, and in that nod was the acknowledgement of something neither of us said aloud, that the system she worked inside every day was not built for people like me, and that the fact that I had found a way through it anyway was not a testament to the system. She walked away to find Marcus. My mother was still standing there. I thought, she said quietly, that you weren't prepared for any of this. The divorce, being alone, all of it. She paused. I thought you needed someone to manage things for you. I looked at her for a long moment. That's what you've always thought. She didn't deny it. I've been managing things my entire adult life, I said. You just weren't watching. She sat down in the gallery chair, nearest to me, on my side of the divider. For the first time that morning, Judge Okafor returned at the end of the recess and spent 12 minutes delivering her preliminary findings. She found the petitioner's request for primary physical custody to be insufficiently supported by the evidentiary record. She found the respondent's documentation to be, and I am writing this from memory because I have replayed it many times, unusually complete for a self-represented party and reflective of a consistent, engaged parenting history. She did not grant everything I asked for. Courts rarely do, and I had learned enough in 8 months to understand that moderation is not the same as failure. She maintained the existing custody split with modifications. Marcus would have Lily on alternate weekends plus 1 evening per week. I would retain primary physical custody, and both parties would be required to participate in co-parenting mediation before any further modification requests could be filed. She also issued a formal note in the record about the pattern of missed scheduled video calls and directed Marcus to demonstrate a minimum of 6 consecutive months of compliance before any future custody adjustment could be considered. Marcus did not react visibly. Diana wrote something on her legal pad. From the gallery, I heard my mother exhale. When the gavel came down, I sat very still for a moment. Then I closed my folders, stacked them neatly, and allowed myself exactly 10 seconds to feel the thing I had been holding at a distance all morning. Not triumph. Not vindication, exactly. Something closer to the feeling of arriving somewhere you've been walking toward for a very long time and standing still long enough to realize you're there. I had done it. I had walked into a room where no one expected me to succeed, where the person who was supposed to love me unconditionally had spent 18 months betting against me. And I had spoken clearly and truthfully, and with everything I had, and it had been enough. More than enough. I picked up my bags. I walked toward the door. The bailiff, a broad-shouldered man with a graying beard who had been watching the proceeding from the corner of the room, gave me a small, deliberate nod as I passed. The kind you give someone you respect. I nodded back. Marcus was in the hallway with Diana, speaking in low, urgent tones that stopped when I appeared. He looked at me with an expression I hadn't seen before in all our years together. Not anger, not contempt. Something more complicated than either. That calendar, he said. The stickers. I waited. I didn't know she was doing that. She started it herself, I said. She's 5. She needed a way to understand where she was going to be. I helped her make it visual because that's literally what I do for a living. He was quiet for a moment. I've missed a lot of calls. Yes, I didn't. He stopped. Started again. I didn't think it affected her that much. She's 5 years old and she asked me why you didn't answer, I said. It affects her. He didn't respond. Not defensively, not dismissively, the way he would have a year ago. He just stood there with the particular stillness of someone trying to absorb something that doesn't fit inside the story they've been telling themselves. Diana touched his elbow gently. Marcus, we should go over the mediation requirements. He nodded, still looking at me. Lauren. I raised an eyebrow. You were, he stopped. Tried again. I didn't think you'd be able to do this without representation. I know, I said simply. That's why I could. I walked past them toward the elevator. My mother was waiting near the building entrance, her coat folded over her arm, the pearls still perfectly in place. She watched me approach and didn't speak until I was beside her. I want to explain, she said. I know. I was afraid you were going to lose her. I thought if Marcus had better resources, she stopped. I thought I was protecting Lily. By funding the effort to take her from me, she closed her eyes briefly. Yes, and I was wrong. Those were not words, my mother said easily. The sentence was short, but it cost her something. I could see it in the set of her shoulders. I've been wrong about you for a long time, she said. You're not who I've been seeing. She looked at me with something that was only beginning to form itself into whatever it would eventually become. You're more than I gave you credit for. I could have said many things. I had, in various imaginary versions of this conversation over the past 18 months, said all of them. But standing there in the entrance of the Maricopa County Courthouse, with the Arizona winter light coming through the glass doors, and a hearing that had gone better than I had dared to fully hope, I found that what I actually wanted to say was simpler. I needed you to be on my side. She looked like I'd pressed on a bruise. I know, she said. Her voice was quiet in a way I didn't hear from her often. I know, Lauren. I'm sorry. We stood there for a moment, not hugging, not quite, but close, with the particular closeness of two people who have a long way to go, but are at least, finally, facing the same direction. The months that followed were not a transformation story. My mother did not become a different person overnight, and I did not stop being angry about what she'd done in the span of one conversation. Trust that has been fractured that thoroughly does not repair quickly, and I don't think either of us expected it to. But things changed. She called more often, and the calls were different. She asked about Lily in the specific way that meant she was listening rather than waiting to advise. She asked about my caseload, my clients, a family I'd mentioned once who had a son with sensory processing challenges who'd made a breakthrough. She remembered details. That was new. In April, 2 months after the hearing, she drove to my apartment and helped me repaint Lily's bedroom. This was her idea. She arrived with paint chips in 4 shades of lavender, and a very specific opinion about which shade worked best with the north-facing window light, which was classic. But she arrived, and she helped, and at one point she was sitting on the drop cloth next to Lily, the two of them painting a section of baseboard together, and Lily was telling her grandmother in thorough and enthusiastic detail about a dream she'd had involving a talking octopus, and my mother was laughing, really laughing, not performing it. And I stood in the doorway with my paint roller and felt something complicated and good move through my chest. She looked up and caught me watching. You should be in here, she said. This baseboard is your responsibility. I came in. We painted together, the 3 of us, until the room smelled like fresh lavender, and the late afternoon sun was coming through the window at the angle that made everything look warmer than it was. Marcus and I settled into the mediation process slowly and with significant friction. He was not suddenly easy to co-parent with, and I'm not going to tell you he became a different father overnight, because he didn't. He was better about the video calls. He was more consistent. Whether that was genuine recalibration or strategic optics, I honestly couldn't tell you. And I decided at some point that the distinction mattered less than the outcome for Lily. She was doing well. She was thriving, actually, in the specific way that children thrive when they feel secure, with a looseness in her body and a readiness to be delighted that I recognized as the signature of a child who isn't carrying weight she shouldn't have to carry. She still kept the sticker calendar, her own idea still, every morning choosing a yellow star or a blue rocket and pressing it into place with the particular satisfaction of a child who understands her own schedule and feels good about it. I kept mine too. A different kind. A journal I'd started the same week I went to the law library for the first time, logging what I'd read, what I'd learned, what I needed to understand next. After the hearing, I kept writing in it. Not about the case anymore. About the work. About Lily. About the strange and difficult and occasionally beautiful process of building a life that is entirely, finally, yours. One evening in May, I was sitting at the kitchen table after Lily was asleep, the journal open in front of me, and my phone buzzed with a text from my mother. I told Aunt Bev about the hearing today. I told her you represented yourself and won. I told her what the judge said about your documentation. A pause. Then I told her I was proud of you. I wanted you to know I said it out loud to someone else. I sat with that for a long time. It didn't erase 18 months. It didn't undo what it had felt like to sit alone at a respondent's table in a courtroom while my own mother sat behind the man who was trying to take my daughter from me. Those things happened, and they changed something in the landscape between us. Some geography that will probably always read differently than it did before. But the text mattered. The fact that she said it out loud to someone else mattered. I typed back, "Thank you for telling me." Then I closed the journal and sat quietly for a while, listening to the apartment settle around me, the specific sounds of a place that belongs to you, the hum of the refrigerator and the distant sound of a neighbor's television, and somewhere down the hall, the soft, steady breathing of a 5-year-old in a freshly painted lavender room, sleeping soundly, undisturbed. I had walked into a courtroom where everyone had already decided the story. I had written a different one, and the person who surprised me most, in the end, wasn't the judge, or Diana Holt, or even Marcus. It was me. I had spent years waiting for my mother to see me, really see me. The way you wait for light to appear in a room where the curtains have been drawn too long. And somewhere along the way, in the law library after midnight, with a highlighter in my hand and a daughter asleep in the next room, I had stopped waiting. I had lit the room myself. If you've ever been underestimated by the person who was supposed to believe in you first, let me tell you what I know now. You don't need their belief to begin. You need your own. The rest, if it comes after. And sometimes, late on a Tuesday evening in May, it comes in the form of a text message that says, "I told her I was proud of you," and you sit with it in the quiet of your kitchen and let it matter, fully and without apology, because you earned it. You really, truly earned it.